Claire, you said I must just remind them about the competition. So please, there are baskets with the colors of the flag of Mauritius, 5. If you collect them, you can win a prize. What is the prize? Okay. There you heard it. Well, they put our book up. I just saw. I wonder if they'll put the book up.
I'm switching. I'm starting on this. And what I said, like, you know, for the effort. So yeah.
It's yours now, multi-factor authentication. And that is like high risk security.
Let's just decide about the red or blue. Hey?
Sorry?
Are we going to do red or blue there at the top?
I like the red.
Okay. Shall we start, guys? Shall we wait? Okay, I'm gonna start, guys. Is that okay? Yeah. Ladies and gentlemen, thank you for attending this very early plenary session after last night's parties, and welcome to the session. Our plenary session represents a book that we will be publishing with Juta about June, July, hopefully this year. And it specifically deals with the extension of labor and social protection to workers in the informal economy. Now, in many countries, informal economy represents a significant part of the economy and the labor market, and it plays a major role in the production of creation and income generation. However, informality puts workers at a higher risk of vulnerability and precariousness. So we are specifically looking at how do we extend labor and social protection to these workers in informal employment. We have all the categories. However, today we will highlight challenges with reference to specific categories of vulnerable workers in the informal economy. We will also, our conceptual framework is based on recommendation 204 with reference to the definition of the informal economy. And throughout the discussions, we will refer to the wider notion of social protection. I will follow very much the same pattern as yesterday. I will introduce the panelists. I will give them a chance to present, and then we'll open it up for questions. So our first presenter is Prof M van Staden. He's an associate professor at the Wits University. Previously, he was at UJ, and he publishes and research widely in labor law, and he's appeared at conferences and published nationally and internationally. He has a very special niche in the sense that he often writes about the interpretation of labor statutes, and he will be talking about social protection, migrant workers, and mental health in South Africa. I'll introduce everyone, can I? Okay. Secondly, Dr. S Ncube is a senior lecturer at the University of Johannesburg and an HOD of practical business law. He researches and publishes in various areas of public international law, including forced migration, and he also has an interest in social security and social protection, and he's a member of various committees and fora in the South African development community. And then, no, I didn't say your title. He will be investigating the international regulation of workers in the informal economy with specific reference to the ILO. And then Ms. KB Mufamadi is a lecturer at the University of Johannesburg. She's also an admitted attorney and a trained CCMA commissioner. She acted as a legal researcher for various judges at the Constitutional Court, and she's currently reading towards her PhD at the University of the Western Cape, specifically looking at the gig economy and Uber drivers. And she was speaking about Sweep South and looking at the legal implications of Sweep South in the South African contents. Then Mr. Louis Koen is also a lecturer at the University of Johannesburg. His research primarily focuses on the interaction between sustainable development, including the attainment of decent work and the international economic law. And he's also presented and published widely, and he will look at the position of cross-border traders, a vulnerable group for certain reasons in the informal economy, and that's also the topic of his doctorate. Last but not least, Ms. K Letsiri is also a lecturer and a doctoral candidate at the University of Johannesburg. She's also researched and published in labor law, and she's also busy with the doctoral studies with reference to the vulnerable position of street traders, and that will also be her topic today. Thank you, ladies and gentlemen.
Thank you, colleagues. At first glance, there doesn't seem to be an immediate or an obvious link between migration, mental health, and social protection. But today, hopefully, I can give you a brief introduction why really we should all care about the mental health of especially migrants and of workers in the informal economy. So first, the relationship between migration and mental health is becoming a new area of study worldwide. Of course, migration can lead to mental health problems. We know that there are significant losses during migration, including loss of life, loss of family, loss of a sense of community. But migration is also a major life transition and therefore a stressor. Quite often it's difficult for migrant workers to assimilate within the new host nation. And there is also problems associated with non-assimilation like xenophobia. Okay. But what is often unexplored in studies is also the fact that absence of mental health care in a country of origin is often a driver of migration. So when we then consider the relationship between migration and social protection, it is clear that migration to many people in vulnerable positions is actually a social protection strategy. And therefore, a lack of social protection measures in a country of origins is a driver of migration. There is also a growing relationship between mental health and social protection. First and foremost, I argue that mental health care is a social protection measure in itself. So if we look at this from the perspective of the interrelationship of rights, I argue that the rights that exist in most SADC nations to social protection mechanisms and to healthcare means that on this broad reading of these two rights, that there should be a right to healthcare that's made part of the social protection system. And then mental health problems often are also a result of the failure of a social protection system within a country of origins. Lack of social protection measures in itself, I argue in my chapter, can cause mental health problems. So, why then is all of this important to informal workers? Well, workers in the informal economy are way more likely to suffer from mental health issues. Workers in the informal economy are also more likely to be excluded from the social protection system of many host countries. Chief and foremost, throughout SADC, there's growing accounts that many migrant workers, especially undocumented workers, are not provided with adequate healthcare protection. Even in cases where formally there's no discrimination within the laws of a country, it's still often the instance that in practice these workers are discriminated against. And then workers in the informal economy are more likely to have migrated or to be a migrant. And workers in the informal economy, chiefly and foremost, are also more likely to be undocumented migrants. In South Africa, for example, we see the growing amount of domestic workers that are undocumented. And it's quite difficult in these instances to extend healthcare to these workers. If you think about this, if going to a hospital runs the risk of you being arrested, then it's something that you probably will not do. So what then is the ways forward? Well, the ways forward lies then in adequate migration controls, in mental health provisions and in the extension of social protection mechanisms. But what is ultimately needed is more integrated regional responses to prevent and treat mental health. And I argue that this may even result in a decline in migration throughout the SADC region. A more integrated regional social protection system would also result in a decline of mental health problems throughout the SADC regions, and measures ultimately to provide for more protection for workers in the informal economy would also do a lot to combat the phenomenon of the increase of mental health problems in SADC. Thank you very much.
Good morning, ladies and gentlemen. Well, my contribution looks at the international and regional framework. And obviously, the starting point and the temptation really is to trace that from the instruments that are available for protection. So one would look at the usual international law instruments that deal with human rights, starting off with the UDHR and through to the ICCPR and so forth, and then thereafter move to the fundamental conventions and all. But obviously, because the theme of the book and the objective is to look at the protection and recommend perhaps changes going forward, my starting point is to ask the question, is that framework adequate? And even if it's not adequate, is a legislative approach the proper approach for protecting workers in the informal economy? And as Marius has just indicated, I also borrow quite a number of aspects from his chapter, particularly in relation to organizing and access to protection, because at the basis of protection is a contact point. And what do we mean by contact point? For domestic workers, for instance, there ought to be some organization of some sort, some contact points that even if you want to lobby government, you have that person that acts as a representative. And yet, when a sector is dominated by illegal migrants, as he has indicated, that becomes difficult because you find that the bulk of those people that operate in that sector are not comfortable to be engaged formally. But obviously, in the aftermath of recommendation 204, which speaks to the transition from informality to the formal sector and what it says, that then becomes my departure point, in that I'm saying the focus then is not on legislating, but on policy changes. And whenever we speak about policy changes, the ball is in the domain of national authorities. And recommendation 204 refers to those as competent authorities. And once it's in the domain of national authorities, then obviously there is not much intrusion that any international organization can exercise because, of course, of the limitations of sovereignty, as well as the twin concepts of available resources and progressive realizations, that is in social security generally. So I've always said to my students, I teach social security law, and they think that having a legal framework is itself sufficient for a transition into protection. And I've always said that is the starting point. And what that does is to give you and I and NGOs and nonprofit organizations a basis for advocacy. That's all that it does. It doesn't extend protection. It gives a basis for advocacy. So my argument really is that instead of a legislative approach from the international perspective, what we need is a policy approach, driving policy. And that is generally the trend when you look at the ILO, you look at regional organizations such as SADC and African Union, all that they've done. In SADC, for instance, we do not have a binding instrument as far as social protection is concerned. And what that tells you is that already there's a discomfort. I do state in the conclusions that if there's an attempt to come up with binding conventions or legal instruments as far as social protection is concerned, that is likely to be resisted. And if it's not resisted and it sells through, the adherence is going to be very low. It's going to be very poor. And what we need is not legislating just for the purposes of legislating, but you want to do so and have that impact, actual changes in people's lived experiences. Now, when you look at the decent work agenda and all those, all the pillars within that direct obligations or place obligations on states. And again, there's very little that any international organization can do as far as legislating that space is concerned. So in brief, ladies and gentlemen, that is what the chapter seeks to do. And in doing that, it doesn't really look at the instruments individually, but as I said, proceeds from a perspective of saying, do we need more legislation? Do we need more binding instruments? And at the risk of repeating myself, I'll leave it at that. Thank you so much.
Good morning, colleagues. I'm going to have a brief discussion with you about the work that I'm doing on my chapter, which relates to a company operating in South Africa and a few other countries on the continent called Sweep South. I like to call them the Uber of domestic workers because that's in essence what they seek to do. But there's a few nuances that I'll touch on during the course of my presentation. And just to give you a bit of context, I think it's very important to talk about the state of domestic work in South Africa broadly before we move over to focus in on Sweep South. And really that context is situated within the context of South Africa as a whole, being one of the most unequal societies in the world. There are extreme levels of poverty, high rates of unemployment, and domestic work really has a very firm footing in South African history and South African society. So we know that also domestic work is impacted by the legacy of apartheid even now. It's historically performed by African and mixed-race women in South Africa. The workers usually come from disadvantaged communities, while their employers come from more affluent communities. The sector employs 14% of the South African women workforce, with women making up 97% of that sector. And most of the workers are internal migrants or immigrants from neighboring countries with limited access to formal education. So that's just to really set the scene. You know, what are we dealing with in South Africa in relation to domestic work? The sector is also marred with exploitation and abuse. Colleagues would know there's been a lot of development in the legal, from a legal perspective in relation to domestic workers throughout the years. In 2002, there was a sectoral determination implemented to sort of create certain rights and responsibilities in relation to domestic work. The National Minimum Wage Act came into effect, and last year, domestic workers were placed on par with the rest of the country in relation to the national minimum wage. In 2019, the Pretoria High Court ruled that the exclusion of domestic workers from COIDA was unconstitutional, and then that was later confirmed by the Constitutional Court. So there's some strides that have been made. So generally speaking, domestic workers in South Africa have access to, will have theoretical access, and I think my colleague will touch on that, theoretical access to a lot of rights, labor rights in our country, you know, such as maternity leave, access to UIF, the right to fair dismissal, access to dispute resolution fora like the CCMA. So there is this theoretical access to labor rights in the country that domestic workers have. But where does Sweep South come in? Sweep South is a domestic work platform that started in 2014. It operates in various provinces in South Africa, but also there's planned expansion to Botswana, Kenya, Nigeria, Ghana. It's a mobile app where clients are able to procure the services of domestic workers for various tasks to be completed in their homes. Domestic workers who are on the app generally report that it's easier for them to find work through the app. but there's concerns about the nature of the operating model. And the main concern emanates from the fact that Sweep South categorizes its sweep stars. They call the ladies sweep stars. They call the ladies sweep stars, and they categorize sweep stars as independent contractors as opposed to employees. And of course, this denies the ladies the fundamental rights that so many domestic workers have in the country. The business operates very similarly to other platforms. They are individual service providers, the domestic workers, and they are deemed to be independent contractors. They perform cleaning services at clients, and clients order their services through the mobile application. It's a lead generation conduit. Anybody who's ever read anything about Uber will find this language very familiar, that Sweep South considers itself only to be a lead generation conduit and not an employer. The platform exclusively uses women. They cover the costs of cleaning supplies, and workers pay for their own transport, and the company communicates with workers through a data-free application. Clients rate the sweep stars, so there's a rating system that is used following their work. And obviously what happens as a result, and I'll touch on it more later, is that workers with higher ratings inevitably get more gigs. The lower your rating, the less gigs, the possibility of deactivation comes. So clients use the booking system to then book these workers. They can add tasks like laundry, window cleaning, etc., to what they want the workers to do in their homes. And I'm not going to take you through Section 200A in isolation. I want to talk about it in relation to these workers specifically. Section 200A of the Labor Relations Act is our starting point when we're ascertaining whether or not somebody is an employee. So the first thing is, whether the manner in which the person works is subject to the control of another person. I think what's very important is that we know a low level of control is necessary for this particular factor to be satisfied. But in relation to Sweep South, there are different elements of control. Apart from the training of the workers, the rating system acts as a very, very significant mechanism for control. And there are issues around discipline, there are issues around performance, there are issues around how often women actually use the app and go to clients, that all lend itself to seeing that there's quite a significant degree of control over the workers. And hours of work. Similarly to what I've said, I think what is really, really interesting is that workers, if they decline too many jobs, 4 jobs in a month, if they decline 4 jobs in a month, they run the risk of being deactivated. There's no discussion with them about the deactivation. The business just says, well, clearly you're not interested in working, and they deactivate you from the account, which ultimately for our purposes really amounts to dismissal. When you look at forming part of the organization, when I think about this factor, I actually think it's very outdated, especially in relation to some of the things colleagues were saying yesterday about the concept of work. What is work now? People don't come into the offices. Is this particular criterion even going to stand the test of time? Because the workplace is simply changing. But in relation to Sweep South specifically, I don't think the Sweep Stars form part of the organization. And working an average of 40 hours over a month. Again, if workers decline too many jobs, they eventually get deactivated from the platform. Economic dependence will be very interesting. Sweep South itself, in its own research, has noted an increase in women working 5 days a week, whereas before, some of the women would sort of take a job here, maybe work for another family here, but now there is an increase of women on their platform who are working 5 days a week, up to 7 days a week on the platform. So there's a development of economic dependence amongst the workers. And provision of tools of the trade. Like I said, Sweep South does provide tools of the trade to the workers. And only working for one person, many of the workers do work only for Sweep South. Again, well, like I had said, there's an increase in workers working 5 days a week or 7 days a week, so that we are getting to a point where workers only work for one person. A very interesting point that I've noted in my research that relates specifically to Sweep South that differs from other platforms is that many of the Sweep Stars get re-requested by the same family over and over and over again. So you will find a lady who is working through the app and is paid through the app, but she goes to the same household every day, sometimes up to 2 years. So for me, I think that that particular nuance will be interesting to look at for Sweep South, because who is the employer in that case? Is Sweep South even still a factor? They are just now providing a way in which this person is paid. So that is really the very interesting nuance with Uber. With Uber, it's rare that somebody will be requesting the same driver, but with Sweep South, it can happen exactly like that. So some of the challenges, again, I think it's clear that if they are not considered to be employees, they lose a lot of protections in relation to the Labor Relations Act and the BCA. There's no maternity leave. A lot of the women report not being able to take maternity leave. 14 days after giving birth, they've got to go back to work. Sweep South says no work, no pay. So, and they exclusively employ women, but there's no consideration for maternity leave. There's no consideration for a woman wanting to take off time before she gives birth at all, and even afterwards. There's no job security. If you take off for maternity leave, you will be deactivated from the account, from the platform, and you need to reapply, in essence, for a job. So there's no job security. The workers have often reported that there's increased earning, but irregular work. They don't always know when they'll get work, especially if their ratings start to drop. Then their work becomes even more irregular. Again, there's penalization for rejecting jobs. The rating system has a huge impact on the way that they work. And they've got no way of rating clients. The clients only rate them. Even if they don't want to go to a particular client, that's where they have to go. They can't reject it, because if they reject too many requests, they get deactivated. There's no dispute resolution forum. The company has said that they will register workers for UIF if the worker has worked for one family for a period of 24 months. So that's a very bizarre condition that Sweep South has created for itself. So it's very interesting to see how this will all play out. Sweep South sort of lauds itself as being, a champion of the platform economy, the most sort of worker-friendly platform economy. But I think that the experience of workers tells us something different. Thank you.
Good morning, everyone. So adding on to what my colleagues have said so far, but my focus will then be on informal cross-border traders as a specific group of informal economy workers. And really what we're also trying to demonstrate is there's quite a bit of diversity in the informal economy. So informal economy workers are not a homogeneous group, and they all have different and varying needs. So in terms of informal cross-border traders, I think it's important to have a discussion about who is actually an informal cross-border trader. Because if you look at it from a trade law perspective, informal cross-border trade is often viewed as unregulated trade that does not go through official channels, that is illicit effectively. And that is not who we are referring to when we speak about informal cross-border traders. So the United Nations Conference on Trade and Development defines an informal cross-border trader with reference to recommendation 204. As you would recall, my colleague said we would refer to recommendation 204 throughout. And recommendation 204 really looks at whether these workers are insufficiently covered in law or in practice. So the focus is on the status of the trader and not the trade. It's even trade that goes through lawful customs channels can be informal if the trader themselves is informal. So we look at the vulnerability of the trader rather than the nature of the goods traded. And of course, it excludes the range of illicit goods excluded in terms of recommendation 204. And that's really the understanding that I adopt of who is an informal cross-border trader. So in Southern Africa, intra-African trade is predominantly informal. There's a very large informal cross-border trade in Southern Africa. Up to 40% of intra-SADC trade is informal. And the face of informal cross-border trade on the continent is decidedly female. 70% of all informal cross-border traders in Southern Africa are women traders. And this has unique implications for what the social protection needs of these workers are. And something else that's quite unique about informal cross-border traders, from a financial perspective, they are much better off than many other workers in the informal economy. So a study on informal cross-border traders trading between Botswana and South Africa found that on average, an informal cross-border trader earns around 10 times the Botswana minimum wage at the time, and that the average informal cross-border trader conducting trade between Mozambique and South Africa earns around 15 times what the lower end of the formal sector workers within Mozambique earns. So this also presents a unique perspective because it shows that often there's an assumption that workers in the informal economy cannot contribute to contributory social insurance, but the reality is that workers in the informal economy are diverse, and some workers may actually be able to afford to contribute to contributory social insurance. So we cannot have a point of departure where we assume that workers in the informal economy can never contribute. But of course, there are other challenges when it comes to, say, for example, extending contributory social insurance to workers such as these. For example, their income is irregular. Even though they earn a higher income, they may go have more income this month and less next month. So their income fluctuates a lot. In certain months, they may have no income, which is particularly true for the traders in curios. So often some of these traders trade specifically in curios, and they would, for example, stay in a particular location for 3 or 4 months and then leave and have no income for some months. So if you extend contributory social insurance to these workers, you would have to take into account and have a method of actually making it possible for them to contribute even with these fluctuating income levels. So that is one of the particular challenges. Another challenge that these workers experience quite often is, of course, violence and harassment. So in a study by the Southern African Migration Program, and the Southern African Migration Program really gives us the most comprehensive statistical picture we have of informal cross-border traders. So for purposes of their study, they observed 205,000 people crossing borders and 85,000 informal cross-border traders to actually arrive at this statistical picture. And what it tells us is that of the traders interviewed, the Zimbabwean traders interviewed, more than 20% of the traders report having experienced verbal harassment by South African customs officials and border officials, and as much as 15% report actually having experienced physical harassment by South African customs and border officials. A similar picture also holds true in respect of traders from Mozambique trading in South Africa, where around 12% of the traders report having experienced physical violence and harassment by South African police and customs officials. And for them, remedies often presents a unique challenge because obviously they're not covered by the Employment Equity Act. And in theory, they are covered by the Promotion of Equality and Prevention of Unfair Discrimination Act in South Africa, which has a unique dispute resolution forum, the Equality Court. But what we also know is that the Equality Court is to a large extent non-functional. In a study by the Commission on Gender Equality, where they visited various of the equality courts across South Africa, found that most of these courts are not operational at all. They don't actually have a clerk or anyone there to assist you. And that's where I look at interesting interventions that have been taken elsewhere on the continent. So particularly, I look at the common market for Eastern and Southern Africa, COMESA, and COMESA has a simplified trade regime for small-scale cross-border traders, which is not really what's interesting for purposes of today's presentation, but it is the specialized dispute resolution mechanisms that COMESA has introduced to assist these workers. And it's not actually a formal dispute resolution mechanism. They introduced trade information desks, and the trade information desk really has no power to make any binding legal rulings against customs or border officials at all. Instead, what their role is firstly to assist the traders to actually complete customs procedures correctly. But if there is any unlawful seizure of goods, they act in a mediating role. So they assist the traders to mediate with the customs officials, and in many instances, they are successful at actually having goods returned to the traders where this has been seized unlawfully. And even though they have no power to make a binding legal ruling, this has assisted thousands of informal cross-border traders on the border posts within COMESA. So for example, between a border post between the Democratic Republic of the Congo and Rwanda, one particular trade information desk receives around 24,000 disputes to resolve per quarter. So those are all traders who are being assisted to resolve their disputes. In cases of harassment, they assist the traders to file complaints using the official processes internally by the border officials. So sometimes the solutions for these workers are a bit different, that they may not always need to be formal court mechanisms. In fact, the reality is that for most of these workers, courts are not accessible, as it costs them a substantial sum of money, and they also don't have the time to litigate, because every time they're away from work, they're of course losing income. So these are some of the challenges I look at in the book, and also some of in the chapter, and some of the solutions I look at specifically for informal cross-border traders. And bearing in mind that I said before, with these workers, it's unique that they have higher income levels, which presents perhaps an opportunity to extend contributory social insurance to them. Thank you very much.
Good morning, everyone. Good morning. My chapter focuses on a category of informal economy workers, slightly similar to the informal cross-border traders that my colleague just spoke about, but also very distinguishable. So this goes further into illustrating the heterogeneous nature of the informal economy and how a one-size-fits-all approach will not work. So we do need some very tailored responses. So I look at workers known as informal traders, and from a conceptual perspective, this category has 3 subcategories. So you have the traders who will erect a temporary built-up structure at the beginning of the workday, and then at the end of the day, they will disassemble the structure. You also have the traders who are mobile street traders, so they do not occupy a specific area, they'll move from one place to another. And then you also have the market traders who are operating from a specific designated area, usually allocated by the local municipalities. So these workers engage in a range of activities, including buy-sell activity. So what they will do is they will source goods from wholesalers, usually in the formal economy, and then they will package these goods and distribute them at a smaller margin. They also provide certain services. Some of them also manufacture goods and then sell them off at a smaller margin. So these workers are usually referred to as hawkers or street vendors in other jurisdictions. They also employ the services of transport providers. So from the wholesalers to their vending posts, They will employ transport providers who will then move these goods from one place to the next. And this then speaks to the job or opportunity creation within the informal economy itself. So the whole book kind of illustrates that there is a lack of labor and social protection in the informal economy, and this is or largely contributes to the vulnerability of these workers. Informal traders face various challenges due to this lack of adequate protection. And this includes, for example, the repressive manner in which local governments will regulate this work. So in South Africa specifically, informal traders are regulated by the Businesses Act. But this is a very broad regulation because the Act will then delegate legislative powers to the local municipalities. So local municipalities are given the power to enact bylaws. So every metropolitan will have its own bylaw regulating informal trade in that particular jurisdiction. And at first glance, this seems okay, but then if you consider best practices and you look at India, for example, you'll find that a piece of legislation, a very innovative piece of legislation has been enacted to regulate street vending is what they call it in India. It contains a very comprehensive definition of the work performed by these workers, as well as regulates how local authorities should approach these workers. So effectively, these workers rely on the use of public spaces. And this is a very contentious area due to the competition that exists in that space. On the one hand, you have the right of informal traders to a livelihood. And then on the other hand, you have the government's right to regulate public spaces. But unfortunately, informal traders bear the brunt of this conflict because then local authorities approach them, as I said, in a very punitive and repressive manner. They view them as an unsightly nuisance, and usually they will then regulate them in a manner that seems to want to get rid of them as opposed to promoting their right to a livelihood, which the courts have said is intrinsically connected to one's human dignity. So there is, of course, as well, a correlation between poverty and the informal economy, and I think my colleagues have touched on that a bit. So you find that a lot of informal traders in South Africa and globally are more prevalent in the more developing countries as opposed to the developed countries. So that illustrates the positive correlation between poverty and informality. They also face challenges in respect of access to courts and dispute resolution mechanisms. So they do not have easy dispute resolution mechanisms. There's also large costs or litigation costs related to approaching courts in this manner. And that's where civil society will come in by representing these workers in the form of class actions. So very briefly, those are just some of the challenges faced by these workers. And then they are exacerbated by the lack of social protection. They do not have the proverbial safety net that is meant to protect them in times of crises. And COVID-19 has definitely exposed the devastating impact of the lack of this safety net. In South Africa, the Human Sciences Research Council conducted a study, and the study showed that due to the restriction of movements, these workers could not perform their livelihood activity. Of course, they are dependent on human traffic. They could not sell anything. There's nobody to sell to because people are restricted to their homes. So in the absence of protection such as unemployment insurance, these workers did not have any money, and then they would then largely rely on relief assistance. Another factor or another challenge in respect of social protection is the lack of maternity and childcare service. So if you take a stroll around the areas where informal traders are more prevalent, it's not uncommon to find a woman informal trader sitting there with their small child because of the lack of childcare services. And here I look at Ghana, for instance, where they've innovated in the sense that they have created a childcare facility in the actual market. So it's in the form of a parent-teacher association, and they leave their children at these facilities. Okay, so that's just broadly some of the challenges that these workers face. So my chapter looks at how local authorities could recognize these workers as legitimate workers instead of approaching them in this repressive and punitive measure, approach them in a manner that takes into account their economic contribution. For example, I spoke earlier about the link between the formal and informal economy. Because these workers source their goods, their contribution to job and opportunity creation as well. So regulation needs to move away from being so punitive and be more accommodative of these workers. Of course, they face a lot of harassment from local authorities as well. And here, the Convention 190, ILO Convention 190 becomes very relevant in providing protection. I also explore the possibility of tailored legislation, specifically regulating these workers, bringing all of the bylaws together and creating a uniform approach. Thank you.
I want to thank all my panelists. Poppy, is your hand up already? Okay, I'm going to open it to the floor. Can we have got a question there? Bongani, I knew you would ask something.
Good morning, and thank you for this wonderful panel. I don't know where to begin. I'll start with the thing that really got to me in terms of this panel. This is a great panel, and congratulations on the book. My brother, Dr. Ncube, are you from Zimbabwe? I don't want you to take it personally. You're from Zimbabwe, yes or no? Right. As a Zimbabwean, as an African, and as a migrant worker yourself, who knows the struggle of our people in South Africa and beyond, as an academic who's trying to spotlight these issues, and as a person who is teaching the future, I'm really pained by the use of the word illegal migration or illegal migrants. It's a language that is stigmatizing. It's a language that is disempowering. It's a language that's dehumanizing. And we hear people from the countries where we are going to seek refuge using that kind of terminology. Is the kind of thing we shouldn't even perpetuate or tolerate, not even in quotation marks, at all, at all, at all. I don't want you to respond to this. Hang your head and repent and withdraw and amend your ways. Please, 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 please. Thank you. Then to my sister, I could say something about each of these because I have an interest in all of these groups, but in the sake of time, the last speaker, thank you very much for your presentation. We need to talk about several things, but one area I think as a labor lawyer, we should be looking at is occupational health and safety and the role that local authorities should play. Because if we look at some of the human rights sort of speak, health and safety at work is a right for all workers. If we look at the decent work agenda, that's a right in the workplace, and that applies to workers regardless of their status. The question is, how do we operationalize it? What is the rationale that we provide for putting the sort of responsibility on local authorities, for example, to pay the costs of that? So I'll stop there, but I'm sure like we'll have time to meet and mingle, but those are the two sort of burning points I wanted to raise. Thank you.
Thank you. And if 2, 1, 2, yeah. Should I close? Okay. One, two. Okay. I think that was a brilliant presentation panel. Contribution. Not to ask you to lift up your countenance, because I thought it was brilliantly well done. You seem to pity legislation with policy as an either or. In my understanding of the presentation, my question would be, we have a hybrid. Why don't we mix the two? Because to enforce these conditions, one needs to drive legislation through policy. More especially because yours is an international and regional instrument. How does one adopt an international instrument but through domestic law, which can be perpetuated through advocacy of policy? Can't we have a hybrid approach?
We'll take one more question there at the back. Two more. Three more. Okay. Okay. So we take two more and then answer and then take the second round.
Thank you very much. I'm James Sinakin from Sierra Leone. I think of relevance to this discussion, I must first of all commend all the presenters, but of relevance to this discussion on social protection is the recently adopted protocol on social protection. That's the protocol to the African Charter on Human and People's Rights. This was adopted last year. It hasn't come into force yet because it requires 15 states to ratify. But I think it's worth looking at because it covers a broad range of social protection issues, including women in the informal sector, migrant workers, and so forth. And once it comes into force, it now requires all of our states who are parties to the African Union to take legislative, policy measures, administrative, as well as budgetary measures to give effect to that social protection treaty. It's binding on states once it comes into force. And then states would have to report on their implementation of that treaty every 2 years. So I think it's worth looking at, and we all need to be part of that dialogue to engage our states to ratify that charter so it will come into force. Thank you very much.
All right. Absolutely. Thank you.
My name is John Bosco Aliu from Sierra Leone. Thank you very much, the presenters. Professor Staden on migrant workers. I'm a migrant worker in South Africa. Social protection covers me. I pay social security contributions in South Africa. But my qualifying conditions are not met in South Africa. I return to Sierra Leone, where different social protection policies applies. Now, my question is, what happens to those social security contributions which I had made in South Africa? Is there any intergovernmental agreement to transfer those funds back to your country of origin? Because I'm asking this, I worked at the Social Security National Insurance Trust in Sierra Leone for some time, and we had a lot of headaches with this issue. People will say, oh no, I had contributed in that country, and now I'm here, my qualifying conditions are not met. Why can't you talk to the Social Security in that country to remit my contributions to this country? And it was a lot of headache. Thank you very much, Prof. I hope you can throw light on that. Migrant workers.
Thank you. I'm going to hand over to the panelists to see who wants to answer, but we'll start with you, Maurice. And then Shrivan, I'll give you a chance.
Yeah, thank you very much, especially the point on the protocol that's been recently adopted. I think that's a very important instrument that's highly needed, because what we have to realize is that the failure of a social protection system in any one given country and the mental health system of any one given country exposes all of Africa to the concerns that it brings together and to the social problems that is caused thereby. So really what we need is an integrated approach. We specifically in the book, we deal both, we deal with it on, I think, 3 levels. We deal with it on the regional SADC level. We look at the African Union perspective, and we also look at the ILO perspective. Yeah, so I think that's very, very important. And I think that the AU has adopted such an instrument is very, very important. And then on the point of portability of benefits, I think that's a problem that especially Africa is struggling with significantly. Quite often now this would be done is by means of a bilateral agreement, but these agreements are few and far in between. And maybe there is a more regional approach needed, or perhaps even an African Union response needed ultimately to ensure for the portability of these benefits. But of course, some of the problems associated by this is that the fact that the social protection systems of various African countries are of course not akin. But I think where there are programs that are similar, that it is really important that we should consider how these benefits should be transferred. Yeah, but I mean, that is a significant problem here, because within the context of migration, it's often as if we assume that migration solves the problem within the host country. There's a problem, you go away and you get to the new country and everything will just be okay. But that's of course not the case at all. So often what's needed is also for a support system in your new country, in your host country. And it becomes problematic when you haven't contributed to a system, or the benefits aren't ported, or even the reverse, when you go back. So it's definitely something that more policy intervention is required on. Thank you.
Thank you. I just want to add something on portability. I mean, that's a major issue for the ILO currently. And we've been approached by the ILO to do a study in SADC countries, which is based on a gap analysis to see where are the problems and the challenges and present that to the government. So I think that's very high on the agenda currently with reference to social protection and migrant workers, definitely.
Thank you. And I cannot resist responding to the classification of migrants, whether it's irregular migrants or illegal migrants, and as Prof Fourie said in introducing me, I also do a lot in migration. And so you'll find that the terms also relate to what space one is making reference to those people. So if you are going to talk about it from an advocacy perspective and the like, then generally one would want to say irregular migrants because it's a resistance stance to the tag of illegality. But in terms of the law, it's an illegal immigrant because there are criminal consequences attached to it. Now, you asked if I'm a Zimbabwean and I'm based in South Africa and the like, of which I am. If I were to be arrested in South Africa when I go back on Friday, and it's for a violation of the conditions upon which I was admitted into the country, I go to the courts under Section 32 of the Immigration Act, which defines what an illegal immigrant is. It will not say I'm an irregular immigrant. So I do understand and have also reflected that problem in relation to classifying people as illegal, this, illegal, that, and the consequences that follow. But if one were to go to court to defend a client that has been arrested for violating their visa conditions, the challenge and the tag that follows you is that of an illegal immigrant. And then in relation to the approach, the legislative or policy, it's not a binary approach at all. So perhaps it didn't come across as well as I wanted to put it. But the point is this: you cannot have a strictly legislative approach. That is not going to work. It's the position in public international law generally, peace and security matters. It's the position with migration that has just come up now. It's the position with literally all aspects where international organizations seek to have an influence, that there is a conscious decision to go soft on trying to prescribe to states how to regulate certain matters. And of course, what you propose is exactly how the chapter places that argument in that even through policy, you can then drive towards a binding instrument. You know, we speak about customary international law and how it is made, opinion juris and so forth. So when that practice is set, when that opinion juris has been established, then the transition to a binding instrument then becomes easy. So actually what I do state is exactly what you have suggested things must look. I don't know if there was anything for me, but I think that's all. Thank you.
There was one more question there. There's another question. Okay, there was three. We'll take these three and then we'll conclude.
Hi, Bruno Lopez from Paris-Saclay University. So first of all, thank you so much for the whole panel. That was really interesting, but my question is for one only of the panelists. It's about health, mental health and social protection. And to be honest, I have one question, but two parts. First of all, but I go quick. First of all, do you think PTSD syndrome, like former soldier or things like that, can be detect in the migrant worker, and for the same time of issue, do you think they can access to a health system in the host country, or when if they had to come back in their former country? And the second question is, do you think because of the harassment, for example, when you are in the new country and you have to work many hours and suffer from more harassment than other workers, do you think that kind of typical syndrome had to be addressed for the protection social of migrant workers? Thank you.
Good morning. Thank you very much for the panel. My name is Rachel Moussier. I work for WIGO, which stands for Women in Informal Employment, Globalizing and Organizing. And I am based in Mauritius, so it's wonderful to have you here and hear about the informal economy in my own country. So one of the things done at WIGO is work very closely with the South African Law Reform Commission on extending maternity protections to self-employed workers. So I just wanted to pick up on the last speaker's comments around the lack of maternity and childcare provisions for animal traders in particular, but of course this could extend to other self-employed workers. And wanted to hear from you as lawyers, if this is a hopeful development, and if it's the fact that is this ongoing discussion in South Africa. Can you hear me? From a regional perspective, we're certainly looking to South Africa and the development, what comes from this commission in terms of the extension of maternity protections for self-employed workers. So it'd just be nice to hear from you on that. Thank you.
Hello, hi. My name is Kelly Thokozela-Mkhonto from the Department of Public Service and Administration in South Africa. I have 2 points. You know, just in response to the President's comment, maybe there is a need for a discourse around the issues of immigration, legal or illegal, because, you know, in fairness to the previous presenter, you know, if you were to actually ask people around, people are really quite divided around this issue. And maybe there is a need, instead of maybe probably attacking him, a need for a clear discussion around this matter and full understanding, or maybe come up with a recommended term to be used, because you know, we are in full support of what he just shared with us and the research that he has done. And also just around the issue of policy and legislation. I just need to be corrected. Were you saying we need to, with policy, test your policy first before you move into legislation? Or maybe we should just focus on policy? I just need clarity there. In terms of sweepstakes, thank you very much, my sister. That was a very interesting presentation. However, I just want to know, what are you doing with the challenges that you actually shared with us? Because there are a lot of challenges, a lot of abuse around that space, because it's just it's a personal space. And the workers also need to be given a space where they also give, information or advice. They fill in a form where they actually rate some of the employers, because if that is just left open-ended, you're opening the employees to a lot of abuse. Thank you very much.
Thank you for that. Okay, one more? Okay, and then we'll wrap up. Okay, thanks.
Right. Thanks to the panel. Very interesting discussions around the informal trading. But one of my reflection is one of the sayings which say, they call me a poacher, but in my village, they call me a hunter. To what extent in your research have you managed to look at how the informal trading become formal without looking into the legalities of that? If you go into DRC, there's a lot of trading that is taking place from the mining perspective, as well as from any other small businesses. You go into Zimbabwe, Malawi, Zambia, and any other, even in Mauritius. To what extent in the book have you maybe reflected upon that, not only looking from a legality perspective? What is that telling us for the future of economy or economic development within Southern or in Africa as a whole?
Thank you very much. I'm going to give each of the panelists a chance to respond, and then we'll conclude.
Okay, yeah, on the matter of the PTSD and harassment, maybe I can attempt to answer both questions in one go. Yes, I think there's of course, the South African Labour Court has said that PTSD is a form of disability. And then, of course, discrimination based on disability is prohibited in South Africa, but also, I mean, harassment on the grounds of country of origins or ethnicity, of course, is also prohibited. So that's all good enough, right? But on the ground, we find, and let me choose my word carefully, with undocumented migrant workers, the protection in practice really doesn't exist, right? It's if bringing your complaint forward means that you may be arrested, then actually it means that there is no protection in place. So that is a specifically vulnerable group that we have to look at. And I think what we have to factor into this conversation is decriminalization of immigration, which is, I think, a broader conversation that needs to be had. But yeah, of course, quite often what happens is both documented and undocumented migrants are subject to severe discrimination within host countries in the SADC regions, especially in South Africa. And it's quite often small little things that contributes to the mental health of the person and to the mental health of the family. So it has broader societal implications that I think we need to discuss further. Thank you.
Just perhaps two contributions from my end. The first on the transition, the last question relating to a hunter and a poacher and the distinction between the two. Now, the very essence of informality is defined in relation to regulation, under regulation, unregulated, and so forth. So you'll find that the transition itself will be highly dependent on integration into the formalized system. So it's not, as Louis said at the end, that it's not an issue of the trade itself, but the trader, and it's not even an issue of how much you make from it. It's the nature of, what you're engaged in and to what extent it is regulated. And Maras has just indicated now that if, for instance, you cannot organize, there are a number of individuals in this room that are trade unionists and so forth, and you understand the value, as I said in my presentation, of a contact point. And that contact point becomes the person or organization or driving engine that takes you towards formality through policy changes. Then finally, future developments. Now, you'll find that when you look at when the first mention of the informal economy came about, it was understood to be something that would have been temporary. But right now, it continues to grow. The numbers continue to balloon. And what we need is not so much how to exterminate it, but how do you provide protection, which is what I say in the chapter. How do you provide protection to those guys while at the same time looking at recommendation 204, which is the transition? Because transition is a long-term goal, how do you provide protection in the interim? So that would be my response to that.
I just want to say something about the transition from the informal to the formal economy. And I think we must be very careful because some people are in the informal economy by choice. They don't necessarily want to move to the formal economy. And secondly, we see a lot of movement between the informal and the formal economy. Sometimes they will be in the informal economy, move to the formal economy, and come back to the informal economy. So I think there are challenges, and we can definitely take the discussion and have it further during tea. I think there's a number of discussions that we're going to have during tea. Can we quickly finish? We've got 3 minutes.
Thank you so much for the question in relation to Sweep South. So in my research in this chapter and also in my PhD, I do make specific sort of policy recommendations about the way I think the gig economy specifically ought to be regulated. But I think that the challenges in relation to domestic work are much broader than the gig economy. They are just manifesting in the gig economy the same way they're manifesting in society broadly. And I think those challenges relate to a couple of things. I think the first thing is education of the South African population. But outside of that, I think that there needs to, and I touched on this when I first started speaking, our context is very important. The way people view domestic work is very important. The realities of racism and classism in our South African society are very important when you're ascertaining how well people are complying with the laws that already exist, because this is not, in my mind, a purely legislative or policy issue in relation to how people interact or with their domestic workers. It is a very private space, and you're making very private choices as an employer. And those private choices come not only from what is law, what you ought to be doing, but it comes from how you view domestic work, the value you place on domestic work, your own personal history of whether it is racism or classism, your economic situation, our economic situation is changing, where somebody might have been able to pay this much, this year or the next year, what they can pay has changed. So that exploitation is actually, it's so layered. And I think it really takes, it needs us to consider all of those layers and all of those facets and realities of our society to regulate domestic work effectively.
I think I'm going to be very brief, just in terms of for example, the trade and newspaper, how we transition to formality. So one of the mechanisms that COMESA has actually tried is by introducing this simplified trade regime. Now, that does not automatically convert these traders into formal sector traders, but what it does do is it's a step towards formality, because these workers who previously struggled to navigate customs procedures now have a simplified process to essentially bring their trade into the formal trade system, but they remain informal, not because of the trade, but because there's still a lack of protection available to the traders themselves. And that's ultimately the focus, is not on the goods or what they're trading in, but them as the people.
Thank you for the question on maternity protection extension. I also want to quickly comment, Vigo, on the work that they do, particularly in respect of statistics for the informal economy. So there hasn't been much locally in respect of South Africa, but there is currently a proposal with NEDLAC, and I'm happy to have a chat with you during the break after that.
Thank you so much. I want to thank my panelists for the discussion, and I want to thank the audience for the very lively participation in this. We really appreciate your comments, and we hope to take the discussions further. Thank you very much.
Good morning. I see that at least we are having a full house. I was scared that some of us will not show up today after having a very interesting night yesterday. So welcome to this discussion with only the two of us. We're going to discuss about the employment law challenges of the human cloud, which should be an interesting topic. And we have Shrivan Dabee, who's an executive from the ENSafrica, based here in Mauritius. He specializes in commercial dispute resolution, employment, competition, and revenue laws litigation. He also has experiences before labor courts and also tribunals. The Competition Commission, the Tax Tribunal, the Commercial Court, the Supreme Court, the COMESA Court of Justice, and the Judicial Committee of the Privy Council. But he also has competition law experiences, which includes advising on merger notifications, but also on joint purchasing agreements, as well as assisting clients in allegations of abuse of monopoly power, as well as alleged anti-competitive conduct in the retail automobile industry. He also has assisted different clients on different issues regarding financial services industry in respect of the largest cartel investigation so far run by the Competition Commission of Mauritius. He has also assisted clients operating in agriculture in respect to investigation of cartel behavior in the supply of meat products. And he also assists clients in all aspects of revenue law litigation up to the Judicial Committee of the Privy Council. So help me welcome Shrivan Dabee.
Thank you. Thank you for this introduction. Good morning, everyone. So, and welcome to the second day of the conference and to my presentation. As the title suggests, I will be speaking about the employment law challenges of the human cloud. The human cloud has been used as a generic term. There are various definitions depending on the papers you look at and the cases you look at. Broadly, the other terms that are used interchangeably for the human cloud are the gig economy, the collaborative economy, the sharing economy, the on-demand economy, or the crowd employment. There may be a slight difference in the terminology, but at times crowd employment is used to define those applications that are not location-based, that address themselves to the wider world, to the wider economy, and are not based on a specific location, do not target people at a specific location. So the definition, there are various definitions that have been put across in respect of this employment issue, but we may summarize it to mean the use of an online platform to bring together buyers and providers of certain service, which are obviously provided against a fee. Now, I'm obviously aware that this topic has been touched upon by quite a few of the speakers during the conference. I will try my best not to repeat what has already been said, but in terms of employment law and these online platforms, what I will try to explain during my presentation is that we have seen from various courts in various jurisdictions judgments and decisions being delivered as to the determination of who would be an employee of whom. What I tried to explain during my presentation is that this decision, this determination of who is an employee may be best left, in fact, to the legislator and not to the courts. We will see when we go through a few of the judgments, not all of them, that there are weaknesses inherent in the court system and in the way in which courts deliver their judgments that may imply that the best solution to this issue is legislation. Before we get into the subject, the importance of online platforms have to be highlighted. As a matter of fact, they allow for flexibility of employment. They allow people to work in a very flexible manner in as much as they are able to decide when they want to work, the number of hours during which they want to work, at least in theory. And again, at least in theory, there's no direct supervision of their work, as would be the case in the more traditional setup. People are also able to work on several platforms, have several, between inverted commas, employers at the same time. And it allows people who would not possibly have access to employment otherwise to gain employment and to be earning a living. But at the same time, it would be dangerous to miss a characterization of an employer-employee relationship. We've heard the figure yesterday that in Europe, for instance, by 2025, nearly 45 million people are expected to be employed via those online platforms. It has been estimated that currently around 1.7 to around 4 million people are mischaracterized as being independent contractors instead of being workers of those online platforms. 55% of those who are engaged in that type of occupation currently earn less than the notional hourly rate in their own jurisdictions. And 41% of time spent is left unpaid. So what this means is that these people spend a lot of time being on standby, waiting for work. They've signed on the platform, they've made themselves available, but 41% of this time is spent not working because there's no work that is given to them. It is also, this gives you what I've just stated, an idea of the magnitude of importance that online work, online platforms now have. The dangers of having a wrong classification of those people as contractors as opposed to employees is manifold. For instance, this means that those people do not benefit from the basic employment protection rights, maternity leave, sick leave, protection against termination, and so on. So this brings us to the question of who is an employee. The touchstone of this determination, obviously, and this applies in most jurisdictions, is that of control and legal subordination. To use a definition that has been widely used, an employee is someone who offers his services to an employer in circumstances and under terms and conditions that put the employee in a situation of legal subordination to his employer. A term which is a term and a test which is obviously derived from the law of agency. But what legal subordination in fact means in practice, you will see on the slide the reference to the seminal judgment of the Cour de Cassation in Société Générale. You will also see that this test, which derives obviously from French law and French law principles, is not at all different to what is applied in the common law world. But since we are in Mauritius, and since in those respects, Mauritian law remains very much influenced by French law, I've decided to use this judgment of the Cour de Cassation. So what it says is that the relationship of legal subordination is characterized by the performance of a job under the authority of an employer who has the power to give orders and instructions, to oversee performance thereof, and to sanction the subordinate for any breaches. So firstly, there is the performance under authority. Secondly, the person in authority has the power to give instructions and orders and to oversee the performance of those instructions. And lastly, to sanction breaches of his instructions. So in the context of online platforms, if we apply this classic test, we will need to determine whether the person who is in the position of an employee, in fact, answers those criteria. So the key characteristics of an online platform is as shown on the slide. But what is of interest to us mostly is the last bubble, which is that, and which is put forward by people, by employers, by those administrating those platforms, is that there is not a classic employment situation, because those people choose when they want to work and they choose the number of hours during which they want to work, which is different from those in a classic employment situation. If we look at some of the, I will show you 3 examples of extracts from the contracts between those platforms and those employees or contractors. You will see the evolution of how the terms that are used by the platforms has changed over time. This one, which is the Amazon one, it simply states that it's a relationship of a principal and a contractor. It doesn't go into the details of the execution of a contract. It is limited in that it says, well, you are not my employee. So the next one, which is TaskRabbit, and I've underlined what I deem to be the most relevant one. So it inserts the provision that the online platform will not supervise the performance of work by the person providing his services through the platform, the task in that case, and adds that it assumes no liability for the way in which the performance of the task is carried out. This one as well will allow you to see that, as from the second part of the clause, it says that the service professional represents and warrants that he or she is customarily engaged in an independently established trade, and that this is his profession. He simply, what this clause tries to convey is that the person offering his services is simply using the platform as a way to connect to his own clients. He has his profession, which is the same as what he's providing, and the purpose for him of signing up to the platform is simply to have access to the clients. So bearing this in mind, we know, however, that the determination is not limited to reading the clauses of a contract. It's a factual as opposed to a formalistic approach. And I think it is agreed that most courts will adopt this approach. But which brings me to what and to my introduction. The fact that in most jurisdictions, there is no precise legislation as regards online platform workers means that, as a matter of fact, any determination will have to be left to the courts. Firstly, the courts have discretion in how they will evaluate the performance, the factual situation between the parties. And we've seen that these can lead to completely different, even opposing judgments when they are faced with more or less the same facts. If we take, for instance, certain judgments from the Netherlands, whereby between two different district courts in the Netherlands on the same basis, on the same facts, one judgment came to the conclusion that there was an employer-employee relationship, whereas the other judgment came to the conclusion that it was a contractor principal relationship. It is also the case that before certain tribunals whereby unemployment benefits are determined, the same tribunal, in respect of more or less the same facts, have reached very different conclusions. So the reliance on those judgments and allowing the courts to make factual determinations may in fact lead to very conflicting judgments. And I've mentioned there the judgment in Lyft. So this is a judgment from the federal court in San Francisco, and the judge was ascertaining the position and came to the conclusion that it was a very difficult task for him to determine what was in fact the relationship. And he used this metaphor that I've quoted on this slide. He said that if ever this question, which is a question of fact, was left to a jury to be decided, which was the case over there, it would be handing a square peg and asking to choose between two round holes, an impossible task according to the judges themselves. So this brings me to the conclusion that this is an area of law where there's a need for legislation. If we take, I've quoted there the preamble to Recommendation 108 of the International Labour Organization about the objective of employment law. If the objective in fine is to ensure that two sets of people who do not have the same bargaining power are able to assert their rights and are made to fulfill their obligations. So this necessity to ensure a fair treatment is, in fact, leads us to the conclusion, as far as I'm concerned, that there is a need for legislation. For instance, the mere fact that we've had to go to the courts so far in all these judgments, and irrespective of the outcome of the judgments, we show that this decision of whether there has been an employee relationship or that of a contractor principle is in fact brought to the courts at the end of the relationship, when the employees' services have been terminated. So it is at the very end of the process that the question of determining what was the relationship all along is in fact put to test. What this would mean for that person who has been providing his services over time is that he has not benefited, or she has not benefited from all the protections that he or she ought to have benefited if it was clear as from the beginning that he was in fact in an employer-employee relationship. Again, the preamble to the ILO recommendation 198 provides quite clearly that the determination of this type of relationship should not be, in the vast majority of cases at least, a difficult question, which is answered only towards the end. Those entering into those type of contracts need to know right at the outset, what am I entering into? What is my status? What are my rights and what are my obligations? And here I want to highlight the fact that bogus employment or bogus sham contractor principal arrangements are not something which happens only in the context of online platforms. It's certainly, given the magnitude of those platforms, and now we've seen the figures, the tens of millions of people who are employed in that way, sheds some light on this issue. But the effect of having sham principal contractor arrangements has an effect on not only on the employer and the employee, but on society at large. You will see that certain firms may benefit from the fact that they are not contributing as they ought to social security, and which puts an additional pressure because of those sham agreements on social security, on the pension of many communities and countries. Yesterday, there was a comment from the audience when this topic came up that there should in fact be, the obligation should in fact be on the employer to show that this is not an employer-employee relationship. In other words, but there is always in those situations a presumption of employment. So it's interesting to see that in this the California ABC test, which has been made legislation and which was derived from case law in California. So there is a presumption of employment between the employer and the employee, and it would be for the business trying to rebut that presumption to come and show that, in fact, these three tests are met, that the person is free from control, that he performs work that is outside of the usual course of business of the alleged employer, and that he's customarily engaged in that sort of business. And you will remember the contractual provision that we had seen earlier on in the case of Handy. So this is an example of legislation that has been voted and which in fact puts the burden on the businesses to rebut the presumption that there is in fact no employment situation. The ILO has also provided for a list of indicators that can help to assist whether or not there is control, and if there is control, there obviously is an employer-employee relationship. I will not go through each one of them, but you can easily see that there's nothing new in those conditions, in these criteria. As a matter of fact, this is what the courts have been applying. But what the advantage of having those indicators is that it sets quite clearly, it helps to achieve certainty in those relationships. The EU, this has been mentioned as well yesterday. In fact, the European Parliament has voted for this directive last month. It had been tabled since quite some time, but it has been voted last month. And what it says is that if there are 5 criteria there, it states that there is a presumption if at least 2 of those criteria are met. And we can easily see that, if we take a few of them, the first one is whereby the online platform sets the price at which the person that is the provider of a service, it sets the price at which it will charge for the services that are provided. So it effectively dictates the remuneration of the person who will be providing the services. So, which is exactly what happens in the case of likes of Uber or Lyft or other similar platforms. You will also see that if we take the second one as an example, it sets the online platform decides about the way in which the service will be provided. So it's not a mere question of how the service provider will present himself, but how does he provide his service? He's obviously offered the possibility of adopting a specific route. And if he does not choose that route, there may be sanctions. So these are also indicators of an employer-employee relationship, as they are indicators of control and the ability to sanction non-adherence to instructions given. You will see, for instance, the last one, which is which concerns the regulation of the performance of the service that has been provided. So what I try to advocate for this presentation is that all of these factors that have been made legislations, for instance, this one, not yet legislation in the respective member states of the EU, but already voted at the European Parliament. What they show is that they use criteria that have always been used in the determination of control by national courts, both in the common law and in the civil law jurisdictions. But they come and say that if there are a number of those indicators of control that are met, then it will be deemed to be an employer-employee relationship. Major advantage of this is that of certainty and that of ensuring that those who are offering their services through those online platforms benefit from rights, benefit from protection that they would have benefited from in a classic employee-employer relationship. So this brings an end to my presentation. So thank you all for listening. Thank you.
Thank you very much. That was an interesting presentation. And I'm wondering, because before we open it up, we've been talking about teleworkers and the gig economy, platform workers and all that, including how the informal economy is now being, now going to platform work. And now you've talked about employment relationship and all that. And I feel as if the reason why we are having platformization and this issue of employment relationship is because there's a certain boundary that labor have. So if you're going to enjoy any kind of labor protections under the labor law, you have to be within a certain boundary. And that means that you have to be an employee and nothing else but that. So my question is, should we be having a situation where we are giving workers protections at work under those boundaries? What kind of boundaries should be there when it comes to labor law? Or should we do away with the boundaries that have been created, especially the fact that these were boundaries that were created during the Industrial Revolution, and labor law is taking, it's not moving as fast. The world of work is changing.
Yes, I think this is a major challenge for employment law as a whole, to keep pace with the way work is in fact being conducted in business. We've seen that in all those judgments, they've been using the same criteria that has been used since for many decades now to determine the issue of control. But what I think we need to bear in mind is that even in the traditional employer-employee relationship, that is without the use of the intermediate platform, we have always come across gray areas of law when we do not know whether there is in fact an employer-employee relationship. But at the end of the day, we need, this is why I advocate for legislation to allow for and to ensure that employment law is able to evolve at the same pace as the way in which work is in fact being carried out. There is a possibility, further possibility of creating another type of employee within our employment laws, which would be like a contractor plus. So not a contractor as we know it, but not an employee as we know it. So a type of intermediate group of persons who would be able to benefit in part from employment benefits, but at the same time keep some of the flexibility of the contractor. In this regard, I think it is interesting to see that some platforms now offer free possibilities to whoever wants to sign up. The classic employer-employee one, the full contractor one, and the intermediate possibility of having a contractor plus. So this is a further possibility. But at the end of the day, I think that the role of employment law should be to ensure that people who are in fact employees are able to benefit from all protection that employment law is able to give to them.
Thank you very much. So we open it up. Anyone who wants a question? Or comments? Yes. There are 3 hands.
Hi, Priyesh Uchana from the Ecclesia Group, Mauritius. Very interesting topic. In fact, I think most of people are struggling about finding what will be the real status of this kind of workers. I have a specific question with regards to Mauritian law. We have introduced the term of atypical worker as well as kind of contractors as well in our legislation. What would be your opinion about this type of work falling under one or the other category?
Yes.
Thank you very much, Mr. Dandy, for that wonderful presentation. My name is Sarah from Kaplan and Stratton in Nairobi. I think I totally agree with what you said about probably the need to have legislation around who is a platform worker. Are they are they employees or are they independent contractors? Because it creates certainty in terms of fair treatment, certainty and fair treatment, both for the employer or the client, as well as for the gig worker or the employee in that context. But I think in as much as this conference is focusing on the issue of terms of employment and employment benefits, there is a wider angle to the whole conversation. For instance, in terms of the nature of services that are provided and whether these are regulated or whether they're legal activities. I think we are aware of a whole industry in Africa, and I know Kenya, for example, has been picked out in terms of what is referred to as online writers, who are really people who are doing assignments for people in Europe and America, and they're sort of gig workers as well. So in as much as we are focusing on the employment terms, we also probably have to look and probably legislate on the nature of activities that they are providing and whether these are actually legal. The other issue I wanted to raise is in as much as platform workers or gig workers are raising these employment issues. There is also the other analog mode of this sort of working, where, for example, we have seen an increase in employers of record who are on paper your employer, but you're being controlled by someone else. So I suppose they raise the same concerns. And, do you believe that legislation, I agree with you in terms of, legislation is possibly a way of safeguarding this arrangement so that it's clear from the onset, whether you're an independent contractor or an employee. And I think that also goes to the question of taxes. Because then people have to decide one way or another. If you're a gig worker, when you get into it, from the beginning, you're responsible for your own taxes. You don't expect any social security or employment benefits. If we decide that they're employees, then they know from the onset where they lie. Thank you.
Yes, I'm Rashid Hossain, Redundancy Board, Mauritius. I'd like to ask Mr. Dabee if he has an idea of those working in the human cloud, the supposed employees or workers in Mauritius. What percentage of those people we have, roughly, how impactful their services can be in our economy. So I understand that with technologies, there are, with technological development, there are more and more people being engaged in that kind of service. So if he has an idea of what do they represent in our market, in our economy. Thank you very much.
Yes, thank you for your questions. I'll take the first question from Priyesh with regards to the two regulations, the home working regulations and the atypical worker regulations. I think the question was raised yesterday by someone in the audience who asked whether, given the definition of atypical worker under one of those regulations, whether this in fact is a regulation under Mauritian law for this type of work. I think that if you look at the definition itself, because the definition includes anyone who provides his services through an online platform, you would fall into that category of them trying, the minister in that case, trying to regulate this type of work. But when you look at the regulations as a whole, it does not at all address this type of work. When you look at what sort of matters that are included, that these atypical workers are supposed to be carrying out as duties, you do realize that there's a major disconnect between the regulations and the business reality of what is being undertaken on online platforms. And this is why also I believe that if for the purposes of legislating in this era, it is very interesting to see what has been taking place, for instance, in Europe, and to have a look at the various papers of International Labour Organization on this issue, because they've made in-depth studies into this, and the way they've addressed the issues from a legal standpoint is much closer to the business reality than these two regulations in Mauritius. As regards the second question, yes, there's a further reason why I would advocate for legislation, especially on the African continent. If we look at the cases in the foreign jurisdictions, many of them have been brought through a certain framework, for instance, class actions. I wouldn't venture to give my opinion on all African jurisdiction, but it would be fair to say that access to the courts by a large group of workers or employees in order to vindicate their rights is likely to be very difficult in many of the African nations, including Mauritius. Not only does this arise, like I said, towards the end of the employment, but in many cases, the court system does not provide the appropriate framework for these people to be able to litigate their rights till the end of it. So that's as far as I'm concerned, on the continent, further reason as to why we would need those types of legislation. And I'll connect the second part of the second question to the third question that has been put. The third one is with respect to Mauritius and to the number of employees in Mauritius that are concerned by online platforms and the gig economy workers. I do not have precise figures, but I would tend to say that it's a small proportion of our workforce. But there's something else which is of interest in Mauritius is the development of employer of records and having the same type of issues arising. Employer of records, I think we do have a service provider in the room in respect of employer of records, but they tend to set up, let's say, in Mauritius and then allow a foreign entity to employ via Mauritius or anywhere else, but not the entity itself employing. So which begs thereafter the question of who is the employee of whom and who is the employer of whom. And this is something which is becoming more and more prominent in Mauritius for various reasons, notably for fiscal reasons, because it allows the foreign entity which is employing not to have a permanent establishment in certain jurisdiction, but instead to use Mauritius and to use double taxation agreements to obtain some form of fiscal advantage. So this is also the interplay between employment and tax in this particular space. But there are, in Mauritius, there are a couple of cases which are pending before our courts on this particular issue of determination of employer and determination of employee, and how does it work in the case of employer of records.
Thank you very much. Thank you all. Thank you all for your questions. It's unfortunately, we cannot take any more questions.
Ladies and gentlemen, good morning. My name is Umang Parag from the Public Service Coordinating Bargaining Council in South Africa. For those of you that know me, you would know that I'm very kind, very caring. So I'd like to begin the session off by giving away a free iPhone. But as the lawyers say, T's and C's apply. So this was actually picked up in the foyer area. It's an iPhone. It looks like an iPhone 8 white. There's a lovely lady and gentleman on the display. I'm not sure who it belongs to, but you're always welcome to come and claim it from me. That's your prize. Thank you. So it gives me great pleasure to chair the session on a matter that is really dear to my heart, which is disabilities. As an organization, the PSCBC is really committed to outreach programs and corporate social responsibility initiatives and assisting people with disabilities. We particularly assist children in an area called Olivenode Bosch. So we are deeply committed to issues of disability and assisting people with disabilities. I have also witnessed firsthand how my blind friend and academic, Dr. Mudli, is a true academic, how he works with ICT and how AI has helped him in the broader sense to conduct his work. And this leads us to the topic for discussion today, which is digital transformation as a tool to integrate persons with disability into the workplace. We have with us an industry expert on the subject matter, who is Dr. Yvette Basson, who hails from the mother city, Cape Town in South Africa. And it's a pleasure to welcome you today, Dr. Basson. Dr. Basson, as I said, is a lecturer in the University of the Western Cape in mercantile and labor law. She teaches company law, law of insurance, and new postgraduate disability law. So without further ado, I'd like to hand over to Dr. Basson, who will then enlighten us on the subject matter. Thank you.
Good morning, everyone. As mentioned, I come from the beautiful Cape Town, but I must say the weather here is a little bit better than it is at home in Cape Town at the moment. Before I get started with my presentation, when I started disability law research about 14 years ago, I didn't know that it would end up being very personal to me as well. I actually have a son with a developmental and sensory processing disorder. So as the years have gone by, I found myself getting more and more passionate about the topic. So you'll forgive me in advance if I start getting a bit fired up. All right, so there we go. That's the title of my presentation. Just a few warnings, caveats. The terminology has been used in so many different ways in this conference. It's actually wonderful to see. So we've got digital transformation, we've got technological advancements, we've got the fourth industrial revolution. Really, it's all different ways of saying the same thing, which is that technology is advancing at a rapid pace, and how can we use that rapid pace of advancement to benefit persons with disabilities? Now, I can speak mostly, of course, to the South African situation of persons with disabilities in the workforce, but I can make a few comments on the position globally as well, and I'm afraid it's a little bit dire. Around the world, persons with disabilities remain the most marginalized group in society. Women with disabilities even more so, but that's a topic for another day. So persons with disabilities find themselves in lower levels of employment across the board. In South Africa, the representation of persons with disabilities in the workforce at all skill levels is around 1% of the workforce, 1%. So persons with disabilities are not only marginalized by exclusion from the workplace, but also experience much higher levels of poverty than their peers. So just some background, and that is true globally. In terms of international law, we do have some provision in place for the right to work of persons with disabilities. That is found in the Convention on the Rights of Persons with Disabilities, particularly Article 27. I'm not going to touch too much on that because it's quite a lengthy article, but it is worth bearing in mind that there is an internationally guaranteed for member states who have signed and ratified right to work for persons with disabilities. Barriers to employment are varied for persons with disabilities. In South Africa, we do have quite a robust labor legislation when it comes to employment equity and the preferment of persons with disabilities when it comes to hiring, promoting, retaining, and advancing persons with disabilities in the workplace. Of course, we've got our constitution, which is transformative and is quite far-reaching in what it requires from both the state and private parties in advancing persons with disabilities in the workplace. We have our Employment Equity Act, which provides that persons with disabilities should be given preferment in employment opportunities if they are suitably qualified for the relevant opportunity. And then finally, and a little bit controversially, we have the Employment Services Act. Now, the Employment Services Act has updated a rather old-fashioned institution in South Africa, previously known as sheltered employment. The Employment Services Act in 2014 tried to rebrand the sheltered employment into supported employment. We'll discuss that a little bit later. Basically, supported employment is meant to be a workplace separate from mainstream workplaces that allow for persons with disabilities to gain mostly practical skills that should, in theory, then enable them to compete in the free open workforce as well. Okay, so we've got persons with disabilities who are quite marginalized, representing 1% of the workforce in South Africa. So what do? We need to increase employment opportunities. Well, much easier said than done. In South Africa, I'm sure you all know, we have one of the worst unemployment rates in the world. We are hovering around, I think it is 36% of unemployment at the moment, which is pretty bad. And persons with disabilities really are not a priority when it comes to creating new employment opportunities. The opportunities that are created tend to be traditional 9-to-5 standard employment, rather than considering other alternatives, which is what we'll discuss later today. Another issue when it comes to the employment of persons with disabilities is that of reasonable accommodation. Reasonable accommodation has traditionally been a very big deterrent for employers considering hiring persons with disabilities. Reasonable accommodation in South Africa is an ex nunc right, which means that it is essentially available on demand. So when a person requires reasonable accommodation from their employer, that reasonable accommodation must be provided within the resources available to the employer and without being too burdensome. So reasonable accommodation is usually quite an expensive exercise. It can involve anything from adapting the physical working environment to providing services and goods to a person with a disability in a workplace. And because of that, really is one of the reasons we have found that persons with disabilities remain excluded from standard mainstream work. So we need to think beyond traditional reasonable accommodation, and that is where digital transformation comes in. I've mentioned the social barriers to the inclusion of persons with disabilities in the workforce. Again, that is a paper for another day. That is something that I often say cannot be legislated away. We do need to make quite a few adjustments to the social standing of persons with disabilities, or the social perspectives of persons with disabilities. So, technological advancements, what are they? How are they useful to persons with disabilities? So there are too many of these technological advancements to mention. I've mentioned the ones that most people would think of sort of offhand, and these are, excuse me, voice to text apps or programs. Specifically, if we're talking about those who are visually impaired, voice to text programs enable the use of technology that was previously inaccessible to persons with disabilities with visual impairments. So voice to text is very much an underutilized mechanism or technology at the moment in South Africa. Assistive devices, very typical lawyer, including a very broad term. An assistive device can range from a wheelchair, a hearing aid, to other items that are less technologically advanced, but are still necessary for persons with disabilities to contribute to the workplace. There are very many of those. Visual aids, again, range from the very simple, providing a large screen, enlarging text, and even color coding certain things within the workplace for easier recognition by persons with disabilities. And then the elephant in the room, of course, that everybody is mentioning at the moment, working from home. So this is where I think there is an enormous potential for including persons with disabilities into the workforce without necessarily compelling them to work in a physical environment that is not equipped to handle them. So working from home may not be ideal for everybody, but nor is unemployment. So it is better, in my opinion, to create an opportunity through the use of technology for a person with a disability to work from home, make that contribution, enter into the workforce, than to be excluded entirely. Okay, so work from home, home-based office equipment, we're all familiar with these by now. Technology, is extremely mobile. And with the use of VPNs in particular, people can now dial into their workplaces, whether they are physically present or not. So really, this technology has been used to take the mainstream workplace home, to create a sort of parallel workforce in one's home. Post-COVID, many companies and businesses are not returning to in-person work. So work from home is no longer as unusual or unique or difficult to implement as it was. But unfortunately, persons with disabilities have found themselves again at the bottom of the queue when it comes to making use of the work from home as an opportunity for inclusion. So how do we reconcile these two things? We have persons with disabilities on the one hand, who may have skills and expertise that are needed in the mainstream workforce. And we've got digital technologies, digital advancements, and assistive technology that could create those opportunities. How do we bridge this gap? Now, unfortunately, I did say I was going to rant a little bit, so here we go. Unfortunately, there really is not much in the way of political will. I always say persons with disabilities are not the sexy group of the electorate. It's not really the portion of the population that tends to form the basis of political campaigns. Persons with disabilities in South Africa make up around 8% of the population, which is not insignificant, but you will not see any politician running on the platform of inclusion of persons with disabilities. So there really is, in South Africa at least, no one asking the question about why persons with disabilities remain excluded, remain marginalized. So from that kind of dire picture, how do we get things moving? Well, we need to think out of the box. We need to think beyond traditional workplaces. We need to think beyond physically sitting in an office with a traditional set of equipment. And we need to think beyond physical environments for persons with disabilities. Working from home compelled us to rethink what a workplace looks like. It would be my submission that we need to look a little bit further than that even, and now start to consider what a workplace could look like for a person with a disability. Work from home at this point is tailored very much to those who have no physical disabilities. It's kind of easy to implement. We use the same technology as we did before, but we have all these advancements floating around, you know, the voice-assisted technology, all those kinds of things, and nobody is utilizing that to include persons with disabilities. So the situation we find ourselves in is really a unique opportunity to get persons with disabilities the opportunities to contribute, to be included in the workplace. Because as I mentioned, there are persons with disabilities who have the requisite skills and expertise that is needed in the workplace. But because the traditional workplace is so structured towards standard employment, towards someone who is not living with a physical or other disability, that persons with disabilities remain excluded. I've given some examples there on how technology could be used for different types of medical conditions. Persons with disabilities who have visual impairments could use, for example, a larger screen, voice to text, applications or programs. Persons with hearing impairments could have visual indication of notifications or visual representation of various items in the workplace. And then persons with disabilities who have psychosocial conditions, the so-called invisible disabilities. There are ways for technology to assist those persons with disabilities as well. If I can use my own life as an example, my son who has a communicative disability, one of the things he can do is communicate via pictures. So he can point out when he wants an item or when he wants to do something or when he doesn't want to do something. All kids are very good at that though. So even the invisible disabilities, there is room to just think a little bit differently about how these people can be included into the mainstream workforce and on a larger scale in society as a whole. Supported employment, as I promised we would talk about. In South Africa, supported employment, as I mentioned, is a system of separate workplaces where persons with disabilities can learn certain skills. There are 11 of these institutions at the moment, I think. If I remember correctly, it does vary. And these workplaces focus mostly on practical skills. So we're talking things like metalworking, woodworking, etc. And the idea behind the supported employment enterprises is that the skills learned there be transferred into the open market workforce. But as I've said there very bluntly, it is very much a failed experiment in South Africa. Not only are the skills learned not being transferred into the open labor market, but the supported employment enterprises themselves run at a catastrophic financial loss every year in the billions of rands. So really that system is not working as intended in South Africa at the moment. It's a little bit better in the UK and Europe, but of course the issue of resources then comes up. I believe in the UK in particular, each separate county or borough has their own website and system for supported employment, and you can seek it out as and when you need it. So that's quite a good example of how supported employment can work well. But in South Africa, supported employment is at the moment, unfortunately, not really a viable solution. And of course, as I mentioned, the skills learned at these enterprises tend to be practical, whereas technological skills could perhaps be better transferred into the open labor market. Then, advantages of digital inclusion. Well, the first one is obvious. It results in inclusion. Persons with disabilities will gain access to employment opportunities that they didn't have previously. So that exclusion of persons with disabilities and the continued marginalization could be addressed. In addition, any money-earning work would result in socioeconomic empowerment of persons with disabilities. As I mentioned earlier, there's very much a lack of political will in South Africa, but by giving persons with disabilities an opportunity to have a bigger voice, at least in the labor market, we do empower persons with disabilities and start addressing that disenfranchisement that they've had over the years. And of course, employment is well established to have a positive impact on various basic human rights, the right to dignity, etc. Disadvantages of digital inclusion. It may be inclusion in the workforce, but not necessarily in the workplace, depending on which route you take. Working from home is still not working in an office environment, which means you may be separated from your colleagues, which is not ideal, and is in fact a form of marginalization in and of itself. However, as I mentioned, at this stage, it would be better for a person with a disability to at least be employed while working from home than unemployed and being at home and it being excluded that way. There are no incentives for employers to invest in new technologies. Similarly, there are no incentives to implement reasonable accommodation in South Africa. There are no tax breaks, there are no funding opportunities, nothing like that. The costs are borne by the employer in its entirety. And in addition, in South Africa, employment equity targets, so the number or representation of persons with disabilities in a particular workplace, is left up to the individual employer themselves. So in theory, that is supposed to be a self-reporting mechanism, but it doesn't really work that well, which is evidenced by our 1% employment of persons with disabilities. And then just to mention that worldwide, the employment of persons with disabilities is not a priority in individual countries, really. Lastly, just to summarize, We have persons with disabilities who have skills and expertise that could make a very meaningful contribution to the workforce in South Africa and beyond. And there are new technologies available to assist them to make that contribution. But the gap, the creating of the employment opportunity is the problem. Because there are no incentives for employers and there is no political will, and at the moment, there is no real large-scale activism for persons with disabilities. We have smaller non-governmental organizations or non-profit organizations that ask questions, but really they don't have much in the way of political sway. So I'd be very interested actually to hear if anybody has any suggestions on how we could get these questions asked at the appropriate forum to make the employment of persons with disabilities a priority. Thank you.
Thank you very much, Dr. Basson, and thank you for adhering to the specified timeframes as well. That was amazing, and I'm truly humbled by the work that you do. And we see how it's possible to integrate people with different abilities into the workplace. South Africa has one of the most progressive constitutions, labor legislation, and employment equity acts. The challenge is the rolling out of these programs. So we have many heads of organizations that can actually make it happen here today. So I would like to now open the floor for questions for Dr. Basson. We see 2 hands on the left, 3 hands. Can we have a mic, please? Chris, first to Katlego in front on the left.
It's a good morning of good mornings. My name is Katlego Sebuko. I'm from the South African Policing Union in South Africa. I think mine, it's more of a question that can either be answered now or can be a thought-provoking question that will be taken into the platform, which you had said you will take it from. But it's more of a concerned one. You're talking about employment of people with disabilities. I think what our country or how things are done in our country is not the right way. And I'll tell you why. People with disabilities are not employed. Of course, the majority that have been exposed to or we have seen are not employed directly from outside to come and work for the organization. We wait for somebody to get injured within our organization. Then we'll push that person to a certain position so that we can make the tick on the quota. Employment equity, we've got somebody with disability. It's very rare. And if ever there is one, I encourage somebody to stand up and say, well, we in our organization, we took somebody who is disabled and we knew that this person is disabled. Because sometimes they become so surprised that you are disabled when you are in the interview. Oh, we didn't realize the building that an on-ramp, off-ramp for people with disabilities. We didn't know that you are in a wheelchair. There was one candidate who was asked, who was told that we never thought we were disabled. And the candidate never said for an interview. He so much turned back and said, no, it seems like here we are excluded. I think I would encourage you to make more research or dig more information into the organization before we can go out and pronounce that we are accommodating people with disabilities. Let's not feel pity for them. When you wait for them to be injured, then you place them somewhere. You have not employed them. They have always been in employment. Then they can't be in the statistics of saying that we are bringing people with disabilities. That's number one. I'll put it there. As I'm saying that, it's a double-edged sword. It's thought-provoking, and you can either answer it now or we'll take it forward. Now, I'll go to number two. Number two, we are talking about there is not enough funding. I disagree with you, and I'll disagree with you with information of substance. I sit in the policing chamber in the Sasita. We were talking about this issue, that a lot of money in the sitters are going back to Treasury that should have been used to implement the programs for people with disabilities. Many a times organizations are encouraged, come up with something new. You know, we are in government departments whereby if you can spend about 4 years there, you'll go to a diversity management for 6 times. We want the same thing. But how about you encourage some sort of innovations within the skills development facilitators, that why don't you create programs for people with disabilities? Why don't we have learnership programs for paralegals? And then we will say, we encourage people with disabilities only, so that they can come in and understand, and therefore they can be employable, other than us, going back to what I said earlier, taking what we already have, and then thereafter claiming to be saying we are employing people with disabilities. So my answer to you in that disagreement is that the question is not whether there is not enough funding. There is funding. We just need to extend the hand and grab that funding and utilize it. Thank you very much.
I think it was more of comments regarding disability being a tick box and taking pity on disabled people, but not really integrating them into the environment, and also getting the SETAs more involved in terms of training. Is there anything further that you would like to elaborate on, Dr. Basson?
Definitely the hiring of persons with disabilities becomes very much a ticking of a box exercise. I know of a specific example of a lady who had 2 tertiary degrees, who was employed as a cleaner at a parastatal organization in South Africa. I won't mention any names, simply because she ticked that box for them. So yes, she had employment, but not meaningful employment according to her skills and expertise. As for the funding, I'm glad you say that there is funding available, but that then comes back to the lack of political will, lack of prioritization of persons with disabilities. So like you say, you need the right hand to do the grabbing of the funding that is available. Thank you.
Thank you very much, Dr. Basson, for the additional input. We can then move to President Pamo, who's 2 rows behind Katlego. We have 5 minutes left for questions, so it's fine. Ma'am, the floor is yours.
Thank you for your presentation. A very quick one. You talked a lot about the situation and the challenges. My question is, what are we learning from other jurisdictions to actually maybe think about how, like, can this be legislated, or how can we improve the legislation to ensure that there is inclusion of persons with disabilities? Thank you.
Thank you. Yeah, I think we did mention there's a lot of great minds, so I think it's a pertinent question that Dr. Basson can answer, is how do we learn from others and take it forward?
I love that question. Thank you. That's my biggest soapbox. In South Africa, we don't have any disability-specific legislation. So all provisions relating to persons with disabilities, whether it's employment, social security, is all scattered around in different pieces of legislation. And more than that, often persons with disabilities have to be read into that legislation, and they're not mentioned specifically. So one of the biggest things that I would advocate for is the introduction of a Disability Act, where you could address all these things in context, in detail, but at the moment it is so piecemeal as to be actually quite useless in practice. So that's the main takeaway from other jurisdictions.
Thank you very much. We do see that there's a lot of legislation that needs to be converged into one document. So I did mention that there are many role players in the room that can probably take this matter forward for us. That's appreciated. There was one last question from the gentleman at the back. He has a mic.
Good morning to all. My name is Tibuhan Tule from the Republic of South Africa, from the Public Health Council. I think what we first need to do is to have a clear definition of disability. Because when you get disabled at a workplace, that's what becomes a challenge, because those targets are then counted instead of bringing in the disabilities. So we are using our target most of the time for those that are already in the system. And therefore, we don't reach out for a number that is needed to include those people that are disabled into the labor market. Now, a challenge that was mentioned in the presentation that I saw acknowledged is that there is no political influence or will in most of the countries, and including our country as well. So what needs then to happen is to ensure that there is that adequate influence politically to be able to address on this matter. Because politically, if you look at it, we don't even consider, or we are excluding the disabled from occupying the political positions that will have an influence on that. Then thirdly, one of the challenges as I experience in my country, the institution of learning for them, they're very limited. It's not spread across the country. And a disabled, say for instance, in one province in the Free State, that's only one. And it accommodates, the neighboring provinces like Northern Cape. So that is a challenge. But if we can spread this learning institution, I think that will help us to identify the skills and the expertise that are needed. And also to have a proper monitoring and evaluation of the employment equity targets for the country, because with that, we will then be able to have a data province by province, looking for those that have that skills. Now, lastly, those that are injured from the workplace and are used as the target, they are actually covered by COEDA. Now they will be benefiting too and excluding the disabled. Thank you very much.
Thank you very much, sir, for those comments and questions. Coming out strongly is a clear definition of disability, which there's lots of blur lines on that we need to actually address. Katlego also touched on the issue of not bringing in fresh blood in terms of disability and just recycling existing people, changing their category from normal employees to a disabled employee. And then the issue of political will and monitoring and evaluation. Those are the key issues that were highlighted by the questions and comments. Dr. Basson.
So thank you very much for your very insightful comments. First of all, there actually is a definition of disability that is in the Convention on the Rights of Persons with Disabilities, and South Africa has signed and ratified the convention. But unfortunately, when we do our country report, which we've only done one in the 17 years since the convention has been around, we're still grappling with issues relating to disability. And I'm not quite sure why the definition in the convention hasn't just been adopted, because it's relatively far reaching. So there is a definition that we could implement. I know the Law Reform Commission is currently looking at the domestication of the convention, so perhaps we'll get some clarity there. Then, yes, definitely. There are loopholes in the employment equity COIDA setup where someone gets injured at work and now changes category. And it's very much just an on-paper change. And it is an easy way out, I think, for employers to tick those boxes rather than putting in the effort of actively recruiting persons with disabilities. And then you mentioned about the schooling. Schooling for children with disabilities in South Africa is truly terrible. The waiting list for primary schools in the Western Cape is around 3 years at this point. So if your child is diagnosed at the age of 5 with a psychosocial disability, they may get into, the earlier levels of school when they're 8 or 9 years old, which is just, it's not feasible. The only other option is private schooling, which is prohibitively expensive and again excludes most people. So absolutely, the schooling of children with disabilities is something that would definitely need to be improved and increased around the country. Thank you.
Thank you very much, Dr. Basson. That was the concluding question. In the absence of no other questions, we can then play. All right, thank you. So there's more input coming through from the online platform, indicating that there needs to be more clear and concise definition of disability. So you're welcome. I'm just going to allow one more question because we're really out of time. So please, if it could be brief.
Hello, thank you. Thank you. That was really intense and pretty interesting subject. And just for you're looking for a way to grab money for the disabilities in France. We have maybe one solution, and I want your feeling about that. But we have a law that imposes to tax a percentage of salary cap for investment as disabilities worker in the workplace or for higher disabilities worker. And the problem is in France, you have you have to choose. You engage disabilities workers or you have to pay. And many companies prefer to pay 6% of the salary cap before hire disabilities workers. So here is the solution. They raise funding. Obviously that work, but the downside is they prefer still not hire workers. So I want your feeling about that, and thank you so much again.
Thank you very much. It's more of a tax penalty, issue that we can actually relate to. So thank you for that. I think it was more of a comment than a question as such. So ladies and gentlemen, that concludes this session. And I think the key takeaway from this is that this ability matters and only we can make a change. So we really urge you to really get involved. There are people with so many skilled people with different abilities that we need to integrate into our society. And the work from home has really made it easier for an employer to actually do that integration. So thank you. The unfortunate part is you're stuck with me for the next session as well. I'd like to thank Dr. Basson. Thank you very much for your valuable input. It's really appreciated.